Yes, good afternoon to everybody. Welcome to the today class of the. This is the Muslim law revision classes because I already told you that I will start from the Monday onwards the revision classes that I posted also that each unit two questions appropriately that I made. But again, I made at the end the disclaimer class also so that you should not blame me later part because it is a luck, it is like a stake, it is a contingent. Whether I should not say contingent, whether it's a wagering, it is. So that's the point which I want to make it out in the today class that yes, please read what I posted on the screen. Anyone? Unmute and read what I put on the screen. Yes?
Good evening, sir. Good evening, sir.
Yes.
Good afternoon, sir.
What I posted on the screen.
Mind is not a dustbin to keep anger, hatred, and jealousy.
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 Jealousy, sir. Ella, sir. Adi.
Okay, next.
But it's a treasure box to keep love, happiness, and sweet memories.
Yes, that is not a dustbin, man. It is the thing which you want to keep the love or happiness and the sweet memories always keep with you. The bad memories you can bury it. That's the point. And good afternoon, Professor Dr. Muhammad Saib Hussain. This is the thing which I posted over there. And today that I posted for all the groups, the two questions from each unit under the family law 2, that is nothing but a Muslim law and other personal laws are concerned. Then in unit 1, 2 questions, unit 2, 2 questions, 3 and 4, there's a total 10 questions are given over there. In your examination also, each unit 2 questions will be asked over there, and you are supposed to attempt how many questions?
5, sir.
5 questions that you have to attempt it. Each question carry how many marks?
Short question 12.5 questions.
Okay.
Long question is 25 marks.
Yes, so that is the proportionately they will meet overall, but the both could be made to the 100 paper. Is it not? So in this class that I will make it to the question number 10, I will start with the unit 5, that is the explain in detail the matrimonial remedies under the Divorce Act 1869 with the reported cases. So either reported cases or a statement of authority or the decided cases or the examples or illustrations, because it is a essay type question, naturally it should be supported with the either decided case class or the examples or the illustration, so that your answer will be concrete answer. So in this class that I would like to explain in detail the matrimonial remedies under the Divorce Act 1869. And when you make it a point, because what are the things should be covered under this one, here I made it very much clear. Yes, read anyone.
The matrimonial remedies under the Divorce Act 1869 may include restitution of conjugal rights section 32, judicial separation section 22 to 25, divorce by mutual consent section 10A, capital A,
Good.
nullity marriage section 18 and 19, children custody section 41 to 44.
These are the things generally that we will study because it is a type question, and hence we have to study in this detail. So let us come to the part that the matrimonial remedies may include, as I said already, that restitution of conjugal rights under the Divorce Act. So in the section 10, grounds for the dissolution of marriage, there it comes over there. One of the condition is that restitution of conjugal rights. In any marriage, all marriage, whether the before or after the commencement of this act, the Divorce Amendment Act 2001 may on a petition presented to the district court, either by the husband or the wife, be dissolved on the ground that since the solemnization of the marriage, the respondent, of course, they have given 1 point, second point. First one is has committed the adultery, and second one is has ceased to be the Christian by conversion to another religion. Yes, the second point, that is the third point is has been, that is the third is has been incurably of the unsound mind for the continuous period of not less than 2 years immediately preceding the presentation of the petition. The fourth is has the period of the not less than 2 years immediately preceding presentation of the petition, been suffering from the virulent or incurable form of the leprosy, and has a then the fifth one is has a period of not less than 2 years immediately preceding the presentation of the petition, been suffering from the venereal disease in a communicable form. Then the sixth is the has not been heard of being alive for the period of 7 years more by those person who would naturally have heard for the respondent if the respondent has been alive. Then the seventh one is that willfully yeah, here you actually we want. This is the crux of the point. The seventh one is has willfully refused to consummate the marriage, and the marriage has not therefore have been consummated. So consummation of marriage is a very much important factor over there in the Muslim law. Without the consummation of marriage, the marriage is not a completed marriage. Then the last point is the eighth has failed to comply with the decree of the restitution of conjugal rights. Here the point they have given the restitution of conjugal rights for a period of the 2 years or upwards after the passing of the decree against the respondent. These are all the grounds which is shown for the dissolution of marriage. Then the question comes over there. A person who has been absent for the BBC more than 2 years and staying separately or staying on the one roof but there is no BBC, at that instance, the aggrieved party may approach the court for the remedy, that is the matrimonial remedy, that is called the restitution of the conjugal rights. Restitution means bring it back, means revive. That is the point which is taken into which is actual meaning of it. So conjugal means is the marital relations. That means the the essence of the marriage is, yes, tell me, what is the essence of the marriage? Yes.
Separation of one's spouse from other side.
The essence of the marriage is procreation of the children, duly recognized by the society as a mark that we will celebrate the marriage, which is an event.
Yes, sir.
So that is actually the thing. When such a thing will not be there, then there is no meaning of the marriage. Of course, it is a separation of the biological phenomena also. That is another point in a legalized way. So, so that also the point where you can take into consideration. But the point here is if a person will not have such a act, then there is no meaning of it. That's why the people will approach the restitution of the conjugal rights because one of the matrimonial remedy which is given under the act. Yes, that is the act resolution of the Muslim Marriage Act. There it is clearly given what are the ground for it. In the one of the ground also, this thing where a person is absent for the BBC for the more than 2 years, at that instance, that is the best ground for the going either any one of the party to the court for the dissolution of marriage. Yeah. So the question comes over here: dissolution by marriage by mutual consent also there. That is a different issue. That the section 10 capital A gives the thing dissolution of marriage by the mutual consent because that is also one of the remedy that you will find it that matrimonial remedy will find. So let us see because we have separate wing that point here at where we can deal that thing. Yes, we deal it separately. That thing is concerned. That is the mutual consent. Of course, the petition for the restitution of conjugal rights will come under section 32. So where the section 32 is clearly mentioned over there, the matrimonial remedies, when either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, either wife or husband may apply by petition of the to the district court, of course, even a district court in the sense, a first class magistrate court also you can file in the case, or in the family court also you can file a case, but the only condition is the judge should be the first class judicial magistrate. For the restitution of the conjugal rights and the court and the being satisfied of the truth of the statement made in such a petition that there is no legal ground by why the application should not be granted, may decree a restitution of conjugal rights accordingly. So that is the thing actually it is say the matrimonial remedy is there. Even the dissolution of marriage points plus matrimonial remedy point. So that is also a remedy in one form in another form to getting the divorce or judicial separation or dissolution of marriage. Which come first? Divorce come first or judicial separation? Yes.
separation, sir?
It is a judicial separation would be there in the beginning because they want to see that whether there would be any chances of the reconciliation between the parties are not there. The last resort is they will attest it. Okay, now it is impossible to make it out. Then better to give the divorce so that let them have their own free life. So that was the thing where we came across that. Then the next one of the remedy is the judicial separation. Yes, that's section 22. Bar to the decree of the divorce mens to ro, but judicial separation obtainable by the husband or wife, anyone. No decree shall hereafter be made for the divorce as a mensa et toro, but the husband or wife may obtain the degree of judicial separation on the ground of adultery, cruelty, desertion, or for 2 years upward, and such degree shall have the effect of the divorce as mens et toro under the existing law, with such a legal effect such an hereafter mentioned. The literal meaning of the term that is mensa et toro means from bed and butter. That is the point. That is the mensa et toro means from bed and board, not butter. Yes, from bed and board. That is actually the point. Bread and butter means it's a livelihood. Bed and board means living together, or sharing the bed and staying under the same roof. So divorce means a is rather a separation of the parties by act of law that a dissolution of the marriage will take place later part. So in the beginning, let them have a separate living, separate from the bed and separate from the boarding, so that that is the first method that they will follow before they are going to stamp the divorce. They will see it. But in any case, after the application of the dissolution of marriage, they will give it for 6 months. Later on, they will wait for some more times. But total time period will be taken. It is at least 18 months. Total, it will be, time period will be taken. But nowadays, because the 18 months is a very lengthy time, so they made an amendment within 1 year. Yes, they can approach. They can take the divorce if it is of a mutual consent or by any other means also, doesn't matter. So that was the subject to the correction. So that was the law is passed over there. At least not less than 1 year should one should have to wait to get the stamping of the divorce. Yes, application for the separation made with the petition. The application for the judicial separation, that is a section 23, any one of the ground aforesaid may be made by either the husband or wife by the petitioner, by the petition, by the application to the district court or the family court or to the court which is having the jurisdiction to entertain the case. At least the magistrate should be a first class judicial magistrate. On being satisfied of the truth of the statement made in such a petition, that there is no legal ground why the application should not be granted, may decree the judicial separation accordingly. So of course, they will see it whether to be given or to not to be given. So by that time, they will see that okay, judicial separation should be made. The literal meaning for the term from bed and board, I already told you. A divorce, a mens et ro, is rather a separation of the parties by the act of law than a dissolution of the marriage. So the beginning is separate from the bed and board, that is judicial separation will be made, then it may be granted for the cause of the extreme cruelty or desertion of the wife by the husband. This kind of divorce does not affect the legitimacy of the children. Yes, nor otherwise the second marriage. Of course, legitimacy of the children is taken into consideration as usual, and the second marriage is not legitimize it because of the judicial separation. So judicial separation is not tantamount to the divorce. That's my point. For mens et ro refers to the case law of the Thomas Kuriakos versus Abraham. There it is very much clearly given mens et toro. In the examination also, if you want to give the total facts of the case, you have to read it. Otherwise, just you can mention the principle laid down over there, and that is enough. That gives a sense that this person has read the case law, and this is very much manifested over there in that case law. So that is the point. What is KLT? KER? Yes? AIR? Anyone? Unmute and give me the
Kerala,
answer.
sir. Kerala, sir.
Yes, KER means that is an abbreviation. That is the Kerala. AIR means?
All India report.
Reporter. And KLT means
Don't know, sir.
Kerala Law Times. So there is a year All India Reporter 2004. There is a High Court of the Kerala, page number 73, and 2003 decision in the volume 2. The 2 is there in the parentheses is volume 2 and the Kerala Law Times and page number 41. This case is cited over there. That is the citation of the case law. Yes, this is the second point where we can say the first point is dissolution of marriage and there is said to be the restitution of conjugal right. The second point is the judicial separation and the third point is divorce. As per the Divorce Act 1869, Section 10 says on which the ground divorce can be obtained. And Section 10 capital A is regarding the mutual consent, which is inserted later part. That's why the A capital is added to the Section 10. Yes, that 10 grounds for the dissolution of marriage that we already seen it. What are the grounds should be there where the marriage will be, where the dissolution can be take place. So these are all the grounds which you made in the earlier also. Then it is a repetition here. That's why that I'm not going through the total grounds. But on this basis also one can get the divorce. But after the judicial separation only the divorce may be possible. Yes, these are the things where that's why I did not repeat it. So now a wife may also present a petition for the dissolution of her marriage. The extra point the wife is having it on the ground that the husband has, since the salvation marriage, been guilty of rape. The additional remedy would be given only to the wife is the rape and sodomy or bestiality. Sodomy means Anna's BBC is called sodomy. Bestiality means man with the animal, animal with the man. That's the human being is said to be the BBC of such a thing is called the bestiality. Yes, these are the things where we can say the ground for the dissolution of marriage by the divorce will be given. That is another matrimonial remedy is available to the any one of the parties. Yes. Now next comes the point. Do you know what is pagan? P-E-G-A-N, pagan. Yes.
Don't know, sir.
Do you know atheist? Atheist.
A person who believes in God, does not believe in God, sir.
In the same manner, it is a pagan also the same person. It is a synonym for the atheist. It is a synonym for the?
Atheist, sir.
Yeah. It is atheist is synonym for the same. Atheist is synonym is pagan, we can say. But a person who believes in the God, what do you say of that person?
Theist, sir.
Theist, we can say, yes. So that is the only thing. Say, I'm getting the barking sound of your pet animal. Yes. Yeah, now the question comes over there. The additional is given over the rape and sodomy bestiality to the woman, where a woman can get for the divorce also. Then the third, not the fourth point is divorce with the mutual consent. Yes, with the mutual consent, there is a new section is added to the section 10. That is why it is represented with the capital A. That is section 10, capital A, dissolution of marriage by mutual consent. So that is how do the mutual consent will be given? Let us see that. Subject to the provision of this act and rules made thereunder, a petition for the dissolution of marriage may be presented to the district court by both the parties to a marriage together, whether such a marriage was solemnized before or after the commencement of this act. That is the Indian Divorce Act. Now the India is removed over there, only Divorce Act is made. So on the ground that they have been living separately for a period of 2 years, of course, they can make the ground that they are living beyond the period of the 2 years, that they have been living separately for the period of 2 years or more, that they have not been able to live together and they have mutually agreed that the marriage should be dissolved. I told you now that the period is reduced to 1 year now, as per the latest amendment is concerned, instead of 2 years. Yes, and the motion of both the parties made not earlier than 6 months. At least minimum 6 months should be there. Before that one cannot make it out. After the date of the presentation of the petition referred to in the subsection 1 and not later than the 18 months. Yeah, that is the period of 18 months is given because the period will be more so that there will be lot of chance for the reconciliation, because the last resort is only the divorce. That's why, and especially the divorce will not encourage by the court if the parties is having the children. Of course, children also will make them to unite together or live together. So not later than the 18 years the time would be given. If the petition is not withdrawn by the both the parties in the meantime, the court shall, on being satisfied after hearing the parties and making such an inquiry, as it thinks fit that the marriage has been solemnized, that the averment in the petition are true, pass a decree declaring the marriage to be dissolved with the effect from the date of the decree. So the minimum time will be given over there for that. There will be a chance for the reconciliation. If it is not made over there, then the last resort is the divorce. That is which is given by the decree is given by the court, competent court, not less than the first class judicial magistrate or the family court or the district court. Yes, next point is point is E. That is the fifth point is the custody of the child. Section 41 to 44. That is the point. But I already told you once, we don't say children, we say only child, because either the heading or subheading or the side heading, generally the singular word could be used over there. Yes, the heading which comes in the center, always the bold, and all capital letters and bold. Then the subheading also the capital letters and bold, which is below the heading, but the side heading would be the left hand indent. There is the left hand side, it will be there, but all the letters should be bold, but the first letter should be capital letter, but the rest of the letters should be small letter, and the first letter of capital letter should be there except the prepositions, conjunctions, and articles. This I already made very much clear in my earlier classes also. So now we'll see what is the custody of the children. Yes, when you say the custody of the children, especially section 41, it clearly makes over there. What is that section read? Can you read the section? Anyone unmute and read? Section 41. Yes. Unmute and read. It's section 41. Yes, please. I'm sure that
Section
you are hearing. Yes, please read.
Sir, for power to make orders as to custody of children in suit for separation.
Good.
In any suit for obtaining a judicial separation, the court may from time to time before making its decree make such interim orders and may make such provision in the decree as it deems proper with respect to the custody, maintenance, and education of the minor children, the marriage of whose parents is the subject of such suit, and may, if it thinks fit, decree direct proceedings to be taken for placing such children under the protection of the said court.
Yes, that gives the sense that before they are going to make it either the judicial separation or the divorce, at that time they would first and foremost should think about the who will be hold the custody of the child. That is very much important factor. After deciding that only that other things can be followed. That is the same thing which is given in the section 41 respect to the custody, maintenance, and the education of the married children. So these are the things, but generally when the child is below the 7 years of age, it will be the mother custody. General practice I'm speaking about. But when you come to the matter of the Christian law, even that Christian law also give the same thing, except the Muslim law. That is the same 7 years, if I not be mistaken, for the both the boy or a girl. And after the 7 years are over, then it will be the custody of the father. But again, the best interest of this child is there. The international instrument clearly says, if the child will be quite good at the father, then it will be the father. If the child will be very good with the mother, then it will be nice with them. So that is the best interest of the child. They will take into consideration. Of course, the court also will make it explanation in this respect, and then they decide better the child will be the custody of the father, or better the child will be in the custody of the mother, because by using the best interest of the child doctrine. So, provided that the application with respect to the maintenance and the education of the minor children pending in the suit shall, as far as possible, be disposed of within the 60 days from the date of service of the notice on the respondent. Of course, the stipulated time would be there where the dispute will be resolved. Then it will be known that whose custody the child would be there. But under the Muslim law, the child custody is different. The Sunni law is different and Shia law is different, as you know it. But again, I will make it very much clear. In the Shia law, they say it is the girl 7 years and the boy 2 years. Custody should be the mother. But in the Sunni law, they say the boy is 7 years and the girl is up to the puberty. So that, of course, not only puberty, they say up to the marriage also. So that was the thing which is made in the different way. Of course, the same thing that made is power to make such orders after the decree, and who is having such a power to make the decree of the custody, maintenance, and the education of the married children, the marriage of whose parents in the subject of the decree, not pending such children under the protection of the said court, as might have been made by such a decree, or by interim orders in case of the proceeding from the obtaining a such a decree was still pending. Suppose interim orders also will be given by the court to see that and whose custody the child must be. Suppose the child is a suckling baby, then anyone?
Should be in the mother's
Only mother,
custody.
suckling baby in the sense breastfeeding, that is. So it is with the mother only it will come over there. The power to make orders to custody the children, suit can be filed over there. The powers to make such orders after the decree of the confirmation, yes, the decree of the confirmation, the court may give the direction and whose custody the child would be there, because keeping the best interest of the child and the maintenance and the education of the minor children, the marriage whose parents were given. So generally what will happen, suppose the wife died and the children are there. At that instance, in most of the cases, irrespective of the religion, they will marry to the sister of the deceased wife. Why? Anyone?
She know about the children because they are nearer to them.
Own sisters.
Yes, sir.
So that's why the affinity would be there. So my children are my sister children. It doesn't make any difference. Even my children's also my children. So that's why they try to make it out. And of course, with the big differences would be there, they would not make it out. With the less difference would be there, yes, it can be done. Because the children's custody is very good, and they will no stepmotherly attitude would be there, rather than going for the new, very what a distant relative or a completely a stranger. So that would be the idea behind it. The best interest of the child will be followed, then the maintenance and of the child, and with the education is concerned, the health is concerned, many other aspect is concerned, it will be given to the generally the mother will take care of it, because father may have the second wife, then it became a step father. So if the mother is very capable of doing the so, at that instant the court also give the custody even after the period of its reach also to the mother. Of course, maintenance should be given by the father. That is the must. Uh, so that is up to what extent? If the girl is there up to the marriage and the boy is there till he will be attained the age of 18 years and he will be independent one, then only up to that extent the maintenance should be given to the children. To the wife is concerned, of course, maintenance for the wife. Of course, the wife death only, the things will happen who will come to the custody here. So custody comes either one of them should be died, parents. So then only that we can think about it. Just a minute, I will come. Asa साहब wait, same timing sir, 6 o'clock. वालेकुम सलाम व रहमतुल्लाहि व बरकातहू। घर तो मालूम है ना? हाँ बस बस वहीं को आ जाना, 6 o'clock को निकल जाएंगे। मैं गाड़ी ला के रख लेता हूँ, खाली आप ड्राइविंग कर दो, होगा, क्योंकि ये गाड़ी भी चलना बल्कि जी। हाँ हाँ बिल्कुल 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 एग्जैक्टली 6 बजे निकल जाएंगे। आप 106 आए तो जरा गाड़ी पलटा ले सकते, पीछे से आना पड़ता है, पीछे से तो विजय टैक्स के पास से आना पड़ता है। हाँ क्योंकि इधर नहीं है, पूरा खोद के है। हाँ तो अगर आप दिखाना चाहते हो एक बार आके देख सकते हैं आपकी। मैं मकान तो वही है मगर सामने से नहीं आ सकते आप। हाँ वो बताना चाह रहा था। ठीक है राइट, रख दो, मैं ऑनलाइन क्लास में हूँ। राइट, अल्लाह। Yeah, I'm sorry for the disturbance because the necessity call would be there. That's why that I heard that you also heard it about the what I spoke with somebody else in the Urdu language. Is it? Yes.
Sir.
Good. Very
Yes,
good.
sir.
Very good. Yeah. So next thing is comes is the nullity of the marriage, section 1819, as per the Divorce Act is concerned, 1869. There is a nullity of the marriage, a petition for the decree of the nullity. Any husband or wife may present a petition to the district court, praying that his or her marriage may be declared null and void. What are the grounds for the null and void? Yes, section 19 sees clearly give the ground for the decrees. Such a decree may be made on any one of the following grounds: that the respondent was the important at the time of the marriage and the time of the institution of the marriage. And I don't need that you need the more explanation for this regard. Okay, the second point is that the parties are within the prohibited degree of the consanguinity, whether the natural or legal affinity would be there. When the prohibited degree would be there, naturally it becomes a null and void. That is also one of the ground. Then either the party was a lunatic or idiot at the time of the marriage. Either the lunatic or idiot, any one of them, unsound mind would be there. At the time, we can say it's a null and void. There's a former husband or the wife, either the party was living at the time of the marriage. Suppose the marriage took place, the earlier wife or husband would be alive or there for the parties. At the time, so we can say it's a null and void. And the marriage with such a former husband or wife was then in force. Nothing in this section shall affect the, of course, jurisdiction of the district court to make the decree of the nullity of marriage on the ground that the consent of either party was obtained by the force or fraud. Suppose the consent is obtained by the force and fraud also, there is also best ground for the nullity of the marriage. Because if the fraud is that he made it, he deceived it, that he said that he did not marry, but he is already married having the wife. But when the wife is living over there, then he go for the second marriage by giving the false information to the other, the lady who would be the second wife, rather I could say. At that instance also, this nullity of the marriage, we can make it out. So that was the thing where the nullity of marriage. When the nullity of the marriage would be there, what would be the children of annulled marriage? Whether they are called the bastards? Yes?
No,
Anyone?
sir. No,
No, they are not called the bastards. They are the valid only. But the marriage will be null and void. Yeah, so the same thing it will be there where the marriage is annulled on the ground that the former husband or a wife was living, and it is adjudged that the subsequent marriage was contracted in good faith and with all full belief of the parties that the former husband or wife was dead, or when the marriage is annulled on the ground of the insanity or children begotten before the decree is made shall be specified in the decree and shall be entitled to succeed in the same manner as legitimate children. What is another name for the legitimate children? Sir, valid children, sir. Legal children, sir. Okay, illegitimate children, another name?
Extramarital children.
Extramarital children, you will say in the another way. To the estate of the parents who at the time of the marriage was competent to contract. I could appreciate that you could remember the wall, which is an illegal child, because you should not suppose to say bastard because it is a unparliamentary way of giving the or saying a particular word. So marital children and extramarital children, that is a polished language, and only the Professor Hussain students could know it. I am challenge it because I told you several times, if you miss my class and you miss many things. So that is one of the reason to try to attend my classes and hear me. And in this class that I only dealt, what are the matrimonial remedies should be there for the Indian Divorce Act. Now the question comes, sir, could the what I say question may be in a different way? Answer is yes. In what way? Yes, I will give you. Matrimonial remedies under the Special Marriage Act. At that time, if they ask you what you are supposed to write, this we dealt it Indian Divorce Act or Divorce Act 1869 something. The Special Marriage Act of 1955 is there. There also the same kind of sections are there? Of course, not same numbers, but the different numbers. What are the things will be covered over there? Generally, yes. Generally, what are the things should be covered over there? Please give me the answer. See, this is the same answer. Forget about the section here. Restriction of conjugal rights, that is one of the remedy. Of course, the Special Marriage Act, there would be a different section. Judicial separation, there is a different section in the Special Marriage Act. Divorce by mutual consent, there is a different section under the Special Marriage Act. Nullity of marriage, different section. Children of custody, different section. That means sections are different, but side headings are
Same.
same. That is the, you have to delete. Suppose if it is asked in the Special Marriage Act. Suppose if they ask you, what is the, what is a conjugal remedies or matrimonial remedies under the Muslim law? If they say because there is no act, of course there is no such a question directly they will ask you. But again they can say the same restriction of conjugal rights, you can make it out. Judicial separation, you can make it out. By following the common law principles or by following the CRPC 125. So in that way also that you can make it a ground to see that how it can be answered. So with this, I would like to stop my class. Of course, they may ask you in this way also. What are the judicial remedies for the Indian Christian Act? Matrimonial remedies. Christian Act is concerned. So if they ask, again you have to put the same 4 or 5 which I made it here, that you put the restriction of conjugal right and judicial separation, divorce by mutual consent, nullity of marriage, children custody. Again, you can say the same thing because these are all said to be the judicial remedies available for the different acts with the different sections. So this way also we can make it out. Sir, is it there in the course outline or syllabus? But it is there in the question paper because in one of the question paper I saw it. This question is asked in that question paper. I will show you the question paper also. See that you can. I put it on the question paper on the yes. Yes, this if you happen to see the sixth small a, briefly describe matrimonial remedies available under the Divorce Act 2000. They said actually there is no 2000 naturally, but the amendment would be there. It is an amendment would be there for that. That's why the reason they will make it 2000. According to the 2000 Act is concerned. But if you happen to say because generally the amendment it is there. So in that way they can ask you and illustrate the important provision of the Special Marriage Act. Instead of saying like this, they will say that what are the briefly describe the matrimonial remedies under the Special Marriage Act of 1954. So even they can ask you in that way also. At least be careful and read in that way so that we can go ahead. When the tomorrow class we will discuss because we discussed today the last point that is the important questions. Yes. Now explain the matrimonial remedies under the Divorce Act 1869 with reported cases. Some reported cases also you should have to give it. If not, at least give that cases which are illustration also. Now in the next tomorrow class, how the property can be divided in the interstate succession of the Christian under the Indian Succession Act 1925 with the sections and illustration and statement of authorities we will see in tomorrow class. That is the interstate succession of the Christian and the Indian Succession Act. So by this one, I would like to take the leave. Thank you very much for your patient listening. But still, there are 2 or 3 minutes to be left over there before you could find it out. If you want to ask any other question, you can ask. Because when you ask, you should keep in mind that this is recorded. This is recorded because it will be uploaded in the YouTube. So you can ask the general question. If you want the specific questions would be there, then you can call me or send the WhatsApp so that I could give the answer to that one. Anything to be asked, please? Yes? Unmute and speak. Yes, anything to be asked? Please unmute and speak. No one would like to speak now. Are you hearing me at least to say? Yes, yes,
Yes, sir. Thank you, sir.
very,
Thank you,
very
sir.
good. Yes, thank you very much for your patience listening. That we will be back tomorrow on the same timings, 3:15. But before I could make it out there, I would like to make it very much clear to that there would not be any class tomorrow because I am traveling to Hyderabad. I will tell you also that why I am traveling. I post it on tomorrow in the group to each and every one because it is not a secret now because secret is between the two is a secret. A secret between the among the three is yes,
Not secret.
open
Open
secret.
secret.
Open secret. Thank you very much. We'll see you tomorrow, and after tomorrow, most probably, if everything